Hello everyone, my name is Geetanjali Singh and this is the second part of the video of general exception under IPC of section 84, the term insanity. Now in this case, in this video we'll discuss about the leading Indian case and the cases under Indian law. Now usually when there is an adequate capacity of the distinguish between right and wrong, the mere presence of an irresistible impulse would not be an excuse of a liability. Now, if irresistible impulse is not incorporated under insanity because it does not fall within the ambit of section 84 of our Indian Penal Code. Now, in the case of an Anmad Koya versus State of Kerala of 1967, it was held that claim to an exemption under section 84, the insanity has to be proved at the time of the commission of the act. Merely losing of self-control due to excitement or irresistible impulse or angriness provides no defense under Indian law, even if this is proved under court of law. And in another case of Ganesh versus Shravan, it was observed that the mere fact that the murder is committed by the accused on an irresistible impulse and there is no identifiable motive for the commission of the act, it can form no grounds of accepting the defense of insanity. Now, a person who is claiming that he managed to take urge of instant his instant anger, and he did that offense losing his self control or an irresistible impulse and taking the defense of an insanity. It cannot be provided by the court of law. There are some leading case in Indian context, and one of them is Ratan Lal versus State of Madhya Pradesh, in which the appellant was caught setting fire to the grass in an open land of Nemi Chand. When he was asked why he did it, he replied, "I burnt it. Do whatever you want." The appellant was charged under section 435 of IPC, and according to in this general exception, the role of psychiatrist and medical examination is really important. And according to a psychiatrist, he was a lunatic in terms of Indian Lunacy Act 1912, and the report explicitly stated that the accused was remains depressed and he did not speak, and in a case of a lunatic depression and psychosis, he requires therapy. Now, the trial court held that the accused was not liable to be punished, and an appeal was filed by the state, and the High Court reversed the findings of the trial and held the accused liable for the offence. Afterward, the Supreme Court allowed the appeal, and the conviction was set aside based upon two major factors that are really important in terms of defense under insanity, which is medical evidence provided by doctors and stamped seal, and according to the behavior of accused on the day of occurrence. Now, these two factors indicated that the accused were insane within the section of 84 of IPC. In another case of Sera Ali Wali Muhammad versus State of Maharashtra, there was an offender who was charged under section 302 of IPC for causing death of his wife and daughter with a chopper. Now, the Supreme Court rejected the plea of insanity because the mere fact that there was no motive proved and that he did not attempt to run was not sufficient enough to prove that he did not had the mens rea of committing the act, that he did not had the intention to kill his wife and daughter. And merely on the basis that he did not attempt to run and he was not knowing the consequences does not set aside did not set aside his punishment. Now, misuse of insanity as a defense under present scenario is there are very high chances that the defense of insanity can be well abused, and it is a very strong weapon to escape the charges of an offense. It is really impossible to prove that the person was incapable of understanding the nature of the act, because you have to prove the state of a mind, which is intangible thing, and it is really important. Now, the defense lawyers can use it for free the culprits of intentional unlawful act. Here the courts play an important role, as they have to make sure that the sane person does not absolve himself by wrongfully using the defense in his favor. In many jurisdictions, this defense has been abolished completely. For example, in Germany, Thailand, and Argentina, this defense does not take place and has been abolished many years ago. Now, to conclude this video, it is suggested that there should be a well-defined definition of mental insanity to avoid the various controversies and confusion that arise in understanding and the ambit of mental insanity and the term insanity, and to understand the differentiation between the mental disease and the actual insanity of a mind sought by the court or so-called legal sanity, in order to make the defense available to the accused so that it can be used properly. That was all. Thank you.